Now, this is the slide where I wanted to come. Benami law and its interplay with other laws. So this is very important issue, friends, that today representing one law, while making representation in one law, one cannot presume to go solo. Solo means unaware of, oblivious to other laws prevailing in the country. It has happened unwillingly, unknowingly, inadvertently that a person has been protected under one law, but pushed deep into other law. So basic awareness of what action under one law will lead to the action under other laws is very essential. And whether this question, whether the provisions under section, the action under Benami will be cumulative, it will be cumulative with other laws, or it will be mutually exclusive, meaning thereby if action has been taken under law, action may simultaneously be taken under other laws also, or what. So it will depend upon the facts and circumstances of the case. I will try to convey my thoughts with the help of few examples. Now suppose a person, Mr. A has given gift to Mr. B, and suppose its valuation has been done in the hands of B while making assessment in the hands of B, and some more addition has been made under section 5610 on the as gift only by the assessing officer. Then Benami law officer cannot treat it as ingenuine gift, because a factual stand has been taken by one authority, unless that is erased or revised or some contrary finding is created. Now, if they start already by the Benami law officer, cannot jump into the picture and also simultaneously make the assessment of gift in the hands of recipient, that is B. So here the actions are mutually exclusive. But actions will not be always mutually exclusive. There may be situation where the tax is also paid and the same transaction can be caught under Benami law also. For example, in one case, a person made surrender on account of bogus share capital, and he paid taxes also thereon. Then after some time, proceedings began at BPU, and then he was examined. And during the course of examination, the facts which were revealed was that since he has already admitted that his company B, his name was R, and his company's name is R Limited, and the share capital received by R Limited from B was bogus. So in the wake of these facts, when the questioning happened, then it was admitted that yes, the cash was given to B, and in lieu of that, B issued check to R Limited, and R Limited in return issued share certificates to B Limited. So then it is a case where it was alleged that B Limited is the benamidar of the shares and R is the beneficial owner. The shares were also attached. Rather, in that case, IOS went one step more and he attached the amount so surrendered of rupees 10 crore lying in the bank account of R Limited also. So in such admitted scenario, it will be difficult to take another stand unless the facts are different, or unless the facts, the admission of giving of cash, etc., is not admitted or not proved on record. Otherwise, it may be treated simultaneously under Benami also. So on the one hand, the person will be paying tax. On the other hand, it may be treated under Benami also. So before making any admissions, any surrender, any petition in the settlement commission, friends, it is essential to be vigilant and to see the implications arising under the other laws also. Similarly, now SBO concept is coming, whereby the companies would be required to disclose significant beneficial ownership interest in terms of the provisions of Companies Act, section 290 of Companies Act, and Ben 1 and Ben 2 has been introduced. So if that compliance is made, and if any kind of things come whereby it is said that the so and so person is the ultimate beneficial owner while acting through another person who has actual shareholder, registered shareholder, then the registered shareholder may be treated as benamidar and the ultimate beneficial owner may be treated as beneficial owner. So in some cases where the GAR is invoked or any PPT test is invoked and the TT benefit is denied, then the underlying asset in India may be treated as Benami asset. Suppose, to give you an example, US company makes investment in Indian company through Mauritius company, and it is held that Mauritian company is just a paper company. It has no existence, no control. Entire control is exercised by the US company. It is just a paper entity, and TT benefit is denied on that ground. You can read the judgment of AB Mauritius, which is on similar lines. AB Mauritius by Authority for Advance Ruling. There are two judgments. Second judgment you kindly read, the same name. So then if treaty benefit is denied on this ground, then in that scenario, the assets which are lying in India, that is the assets which are invested in India by way of shareholding by the Mauritius company, may be treated as Benami asset of that Mauritian company, and the ultimate US company may be treated as beneficial owner. Their prosecution may not take place for want of territorial jurisdiction, but of course the assets being located in India may be liable to be attached.